Let me introduce you to our audience, and maybe a few others will log in as we're talking, but it's a real treat to have you here, Seth. We plan to have you here in person, and hopefully we'll be able to do that before too long. But to those of you who don't know Seth Stoughton and his work, Seth is visiting us from not too far away at South Carolina School of Law, where he's also an affiliated faculty in their Department of Criminology and Criminal Justice. Seth has been writing about policing since he began as a legal academic, and has written some wonderful, more popular pieces on policing issues, since policing has been a popular topic and a real urgent topic just this past year. But obviously policing has not been a forgotten topic for decades now. And Seth served as an officer with the Tallahassee Police Department for 5 years, and he helped to train officers, helped to write policies. So he knows policing from the inside. He did also investigative work in the Florida Department of Ed's Office of Inspector General. All of that was before going to law school at the University of Virginia, where we met, where I was teaching at the time. And it's a real treat to hear from Seth about his new book, Evaluating Police Uses of Force. He wrote the book with Jeff Noble and Jeffrey Alpert, who he's collaborated with over the years as well. The book came out just last year from NYU Press. You can order your copies. You can see a copy placed just by Seth's shoulder there. And so
there it is.
Our plan is to hear from Seth for like 20-25-ish minutes, overview of a kind of a tour of the book. But then please, at any time, do the hand raise. We'd love to have some Q&A, and I have questions, but I'm sure you all will. So please, do the hand raise whenever you think you might have something you'd like to ask our guest. So thank you so much, Seth. I'll turn things over to you.
Thank you very much, Brennan, for that great introduction, for having me, and for continuing to support me despite maybe having known me as a law student. I love the way our interactions have maintained and changed over the years.
I guess I should mention that we were co-authors. I never even disclosed that. We have a great article that we wrote together on police tactics and the theory of the Fourth Amendment.
I was going to mention that as part of the way our interactions has changed, but I wasn't sure if you left it out intentionally, so I didn't want to bring it up in case you were ashamed of it.
No, very proud of it.
Yeah, it's a good piece. Yeah, so what I thought I'd do is ramble a little bit about the book, talk a little bit about the motivations for the book, sort of outline the structure of the book. I will also note no one should buy the hard copy, particularly since now the soft cover is available, and NYU Press has played with the pricing in ways that, well, the soft cover is just more affordable. So, okay, my co-authors and I are a little bit of an eclectic bunch. Jeff Alpert is a criminologist here at the University of South Carolina. He has I don't even know how many decades, probably coming up on 4 decades of research on policing and the high-risk aspects of policing, including vehicle operations and the use of force. So he brings a very empirical eye towards this area. Jeff Noble is a former police chief and police consultant. He's done expert witness work on some of the high-profile use of force cases, including he was one of the experts in Tamir Rice, hired by the family in that litigation, in Philando Castile and some other ones. And he brings the managerial perspective, right? The command staff perspective. And then there's me, the low guy on the totem pole. I bring the legal scholarship and get to do most of the scut work because rank has its privileges. Except when I'm working with you, Brandon, where you do all of the work in a remarkably short period of time, and I end up feeling unproductive by comparison. So we were like, the three of us were literally talking one day. I forget if it was via email or text, and we were pointing out these prosecutors who were making decisions about use of force cases and whether to decline prosecution in use of force cases, and they kept talking about the constitutional standard. They kept talking about the Fourth Amendment. And we were like kind of going off the walls. Like, why do they keep talking about the Fourth Amendment? The question is whether there's a violation of state law, not whether there's a violation of the Fourth Amendment. And from those conversations emerged this idea that we would write a book about how to evaluate any given use of force. This book is not about use of force in the aggregate. It's not about use of force in society generally. We leave a whole lot off the table, essentially, or maybe we leave it on the table, having not taken it off the table, where we know we're omitting really important conversations about race and policing and different types of traffic stops. But what we try and do is answer what we think is a pretty fundamental question that hasn't been terribly well explored, and that's, as society is looking at a particular use of force incident, how do we assess it? How do we go about evaluating it? What are the standards that we use to determine whether it was right or wrong, good or bad, whatever the right terminology is? How do we even figure out what the terminology is, right? So that's the position that we started from. And the first 4 chapters of the book describe what we identify as 4 different evaluative standards, although it's probably better to describe them as categories of evaluative standards or evaluative frameworks. The first one is maybe the most obvious. That's the Fourth Amendment. That's constitutional law. So in brief, there are a handful of very important constitutional law cases. There's Tennessee v. Garner from 1985, the deadly force case that says that officers can only use deadly force when they have probable cause to believe that a subject presents an imminent threat of death or great bodily harm to the officers or others. Followed in 1989 with Graham v. Connor. Graham v. Connor pulling on some threads that were in the dissent in Tennessee v. Garner. Graham v. Connor set up the objective reasonableness framework. That is, officers' use of force have to be evaluated under the Fourth Amendment. It's a Fourth Amendment seizure. That's the relevant constitutional provision for most police uses of force. And they just have to be objectively reasonable, with some guidelines that the court offered, the so-called Graham factors, which I can get into in the Q&A, I think, but I don't think we need to dive deeply into the weeds there, along with a pretty deferential standard. So we're to look at the scene the way a reasonable officer on the scene would understand it, and we have to keep in mind as we're determining what counts as reasonable, that an officer is facing tense, uncertain, and rapidly evolving circumstances and maybe have to make a split-second decision. So in the first chapter, in this constitutional law chapter, we identify the contexts in which the constitutionality of use of force comes into play. Primarily, that's civil litigation under 1983, alleging Fourth Amendment violations, but also some criminal prosecution. For example, prosecutions under 18 U.S.C. 242, the willful deprivation of constitutional rights, or the federal statutes on conspiracy to violate civil rights and the like. And then what we try and do in that first chapter is really lay out a framework for applying this rather facially nebulous, objectively reasonable standard. This is the paper that Brandon and I wrote, A Tactical Fourth Amendment, where we essentially point out that this concept of objective reasonableness doesn't mean a whole lot in the abstract. It requires definition. And what we argued in our paper was that the courts need to draw that definition from the best practices of policing itself. In the book, we take I don't know, 2 or 3 steps back from that and say, well, how do we even begin to evaluate objective reasonableness? And we identify that there has to be a legal predicate, that there has to be a legal justification for the use of force, and that the use of force has to be proportional. That is, there has to be a threat to a legitimate interest. This is building on the work of Rachel Harmon at Virginia, and that the officer's use of force has to be a proportional response to the threat presented. Without diving into the weeds too much, I want to just make a couple of points about some of the vagaries of constitutional law that I see evade attention in a way that I don't like. First is a distinction that we make in the book, and this is a somewhat technical point, but I think it's important, a distinction that we make in the book between threat and risk. using both common law and police definitions, like from the International Association of Chiefs of Police, my co-authors and I focus on this concept of threat. An officer can use force to address a threat to a certain type of government interest. The threat, for example, that someone who officers have probable cause to arrest may get away. The threat of evasion of apprehension, right? Or a threat of safety. Someone who is assaulting officers or assaulting someone else creates a threat to their safety. And a threat exists when the individual has the physical ability to cause the particular harm in question, like the physical ability to run away, when they have the opportunity to cause the harm in question, and when they have the apparent intention to cause the harm in question. And the reason that that concept of threat is so important is because in the objective reasonableness analysis and with the deferential framework that courts generally apply, often we've seen courts credit fears that don't have specific and articulable facts behind them. We see officers who use force and say, well, this person might have done something. Maybe the best example of this is a case in Albuquerque where officers were interacting with a homeless individual who was naked at the time and was standing on some rocks. And they deployed a police dog that ended up biting this individual. And the justification was that, well, at any moment he could have bent down, picked up a rock and attacked the officers. And to be clear, that's true, right? At any moment he could have done that. But that was a risk. It wasn't a threat, because while he had the physical ability to bend down and pick up a rock, he didn't have the rock in hand yet. He didn't have the physical ability to attack officers with the rock just yet. And while maybe you could say there was opportunity, he was physically close enough to the officers, there were no facts that officers could point to indicate that the guy had the apparent intention. So although it seems like a somewhat technical line, this distinguishing between threat and risk is, in our view, actually really important to applying the constitutional standard, this Fourth Amendment standard. I'll also put in a shameless self-promoting plug about a more recent article called How the Fourth Amendment Frustrates the Regulation of Police Violence, where I talk about how the Fourth Amendment doesn't do a very good job in a range of contexts in actually regulating police uses of force. So that's all the first chapter, constitutional law, and a roadmap through the analytical process for constitutional law. The second chapter, we turn to state law. And one of our big observations here is that state law is often distinct from constitutional law. Not always. Some states like Ohio, Vermont, Florida in some ways, have incorporated the Fourth Amendment standards into their state law. But in many states, they don't. There's no incorporation of Fourth Amendment rules. There's maybe not even any reference to Fourth Amendment law in state court decisions that apply state law. So in those states, like in California, when the LA prosecutor is applying the Graham v. Connor standard to determine whether the officer has committed a crime under state law, our argument is that's actually the wrong law. That's the wrong legal standard. After we make that point about the distinction between constitutional law and state law, we identify the state laws that regulate police uses of force. Both state law typically divides between deadly force and less lethal force. And states are kind of all over the map with the statutes or common law regulations that they create. Most states, 42 states, have deadly force statutes. 37, I believe, states, at least at the time we were writing, 37 states had less lethal force statutes. Some states, the eight of the yeah, you know what I mean. The 8 remaining states have no statutes. They just have common law decisions. And the context or the contours of those state regulations really differ quite a bit. For example, in the deadly force context, about 5 states by our count still adopt the fleeing felon rule that the court said did not meet the Fourth Amendment standards in Tennessee v. Garner in 1985. The fleeing felon rule was a rule that allowed officers to use lethal force to prevent the escape of a fleeing felon. Well, today we still have 5 states that give officers a justification defense when they use deadly force to prevent the escape of a fleeing felon. So here's a really powerful example of the distinction between constitutional law and state law. And I'm going to take us all the way back to Ferguson and the Michael Brown case. When the officer, Darren Wilson, was in grand jury, the grand jury was given the Tennessee v. Garner standard that said fleeing felon rule is unconstitutional. You need more. You need probable cause of an imminent threat or of death or great bodily harm. But they were also given the Missouri statute. And the Missouri statute allows officers to invoke a justification defense. It says that officers are justified for using deadly force against fleeing felons. So what's the grand jury to do? What if they had determined that Michael Brown was a fleeing felon who did not present a risk of death or great bodily harm? There's a right and a wrong answer to that. And the right answer as a legal matter is the grand jury is applying the state criminal law standard, not the Fourth Amendment standard. So that means that the state criminal standard or the state law standard is really important, separate and apart from the constitutional standard. Here are a couple of other ways where that's where these distinctions come into play. A handful of states, Tennessee, New Hampshire, I think Iowa, have exhaustion requirements on the use of deadly force. That is, the state statutes say that officers cannot use deadly force until all other reasonable means of apprehension have been attempted or exhausted or the like. The wording varies a little bit from those states. The Fourth Amendment has no such requirement. In fact, the Fourth Amendment case law specifically says that officers don't have to use the minimum amount of force. We can quibble about that, whether it makes sense as a policy matter, but that's the case law right now. So in some ways, state law can be far more robust, far more protective than constitutional law. Lots of variety in state law. We have 50 different states. One of the things that surprised us as we were doing the research for this is a number of states that have state statutes have no decisions, no judicial opinions that actually apply their state statutes. They just don't seem to have any use of force cases. They have statute, but they don't have any case law interpreting it, which I think is kind of interesting. All right, so we have one Fourth Amendment, even if it may be interpreted a little differently in the various circuits. We have 50 states with statutes in common law. Chapter 3 is about agency policies, police agency policies. And there are 18,000 different police agencies. If the state laws are all over the place, the police agency policies are really, really all over the place. Again, Brandon and I wrote about this in our Tactical Fourth Amendment piece, where we surveyed the 50 largest police agencies and identified some of the variances in their policies. When you look nationally, or when you look at the studies that have been done of police agencies all over the place, there's very, very little consistency. There's no consistency in terms of use of force or tactical philosophy. For example, whether we want officers to be very aggressive or to exercise more restraint. There's no consistency with regard to how we classify resistance. Some agencies say, well, there's level 1, 2, and 3 resistance. Some agencies say, look, there's up to 9 levels of different resistance, right? Same thing with how we classify the use of force. So instead of trying to do anything like an exhaustive examination of how agencies regulate the use of force, we try and identify regulatory concepts, regulatory models. We talk in the chapter, for example, about the incremental model, the force continuum that exercises tremendous influence, that more than 3/4 of police agencies still use some type of graphical force continuum or force matrix, which essentially says what level resistance was the person offering, force did the officer use, and when those two things have a match, it was presumptively reasonable. We also talk about some of the newer models, the situational tactical behavior model. We talked about models from Australia, models from Canada, that try to address some of the shortcomings of the incremental model. We also identify policy components that we think are particularly important or common. Things like mission statements and definitions, those are the easy ones. but also concepts like tactical guides, right? Instructing officers to use good tactics to preserve their own safety, force minimization policies, intervention policies, components that you're not going to find in statutes or necessarily embedded in the Fourth Amendment, but that it's pretty easy to find and pretty easy to implement as a matter of agency policy. The fourth chapter in that first part of the book shifts. So instead of talking about a legal standard like constitutional law or state law, or a legalistic standard like agency policy, we go into what we describe as the community expectations standard. And our observation here is that when we talk about use of force, the police and the public ask two totally different questions. Police agencies and administrators ask, was it legal? Was it justified? And what the public tends to care about is, was it avoidable? Was it necessary? Did it seem like it needed to happen? So in that chapter, we try and identify and respond to a number of different types of perceptions that community members may have about the use of force, including perceptions or perspectives that tend to be favorable to the police and perspectives that tend to be a little more critical of the police. So I'll give you two quick examples. In the favorable perspective, we often have the response, well, if this person didn't want to have force used on them, they shouldn't have resisted. Everyone, I think, has heard some argument kind of like that. We identify that argument, we describe it a little bit, and then we explain where it falls short. Namely, the fact that someone resisted is certainly relevant to an assessment of a use of force. It might answer the first question, is force justified? But it really does nothing to answer the second and more important question, was the amount of force used justified given the situation, right? Given the amount or the type of resistance. So when you say if they didn't want to have force used on them, they shouldn't resist, we could all say, okay, yeah, right, fine. There is something to that. But just because they did resist doesn't mean that the officer used, that it was appropriate for the officer to use that amount of force, right? On the critical perspective, one of the common things that we've pointed out is, well, officers stop someone for some stupid reason, let's say something like jaywalking, and then they use deadly force. And sometimes community members conflate, well, he was shot for jaywalking. That's often not the case. We're missing some potentially important intermediate steps. One, we acknowledge that we can have and should have an important conversation about whether officers should be making stops for jaywalking. But as we're analyzing that's a big picture policy question. It's important. But when we're analyzing a specific use of force, we have to avoid conflating the justifications for the underlying stop with the justifications for the use of force. Let's say officers stop someone for a stupid reason like jaywalking, but then that person pulls out a gun and starts shooting at them. The officers don't respond and use force because of the jaywalking. Their interaction is certainly because of the jaywalking, but the use of force has a little bit more proximate justification. So those are the first four chapters: constitutional law, state law, agency policy, and what we call community expectations. The fifth the fifth chapter, we provide as best we can an overall summary of police tactics, explaining tactical concepts. The reason for which is you can't, as Brendan and I have written about, you can't properly evaluate a use of force without also considering the tactics at play. And tactics are basically just a series of decisions or approaches that officers use to manage risk and threat in a situation. And the sixth chapter is about the force options themselves. These are the tools, techniques, and weapons that officers use in use of force situations. The idea here is that if a reader doesn't understand how a baton is used, which may be a little simplistic, it's a stick, right? So let's make it a little more complicated. If a reader doesn't understand how pepper spray works, or how a taser or other electronic control weapon works, then it's very difficult to assess whether officers use that particular tool appropriately or not. So that's it. Those are the 6 chapters. In the conclusion, we make a couple of recommendations, the first of which is to include a discussion of tactics and the centrality of tactics as we're evaluating officers' use of force. The second of which focuses on this concept of risk and threat, that it's not, that we really need to have a threat-based understanding of use of force. And the third is the embarrassing lack of data. We have just crap data statewide, nationally, regionally on police officer uses of force, which makes it very difficult to have an empirically informed public policy conversation. So that's the book in a nutshell, and I really look forward to your questions.
Great. Well, please raise your hands. I have a question just based on the last thing you said. So, I mean, even since the book came out, we've seen laws introduced at the state level. I think maybe there's a federal proposal too to require or support better police data collection. And I'm interested in your perspective on these things. Like, I assume that if it's a federal effort to promote different types of police data collection, whether it's on use of force, non-deadly uses of force, or other topics, that, I mean, the federal government's ability to promote the data collection across lots of small policing agencies is going to be maybe face challenges, and even at the state level, there are going to be challenges. So I'm just interested in your reaction. Do you think these laws are still a good step forward? Is it going to be a slog? Does it at least set a model, and hopefully over time we'll get some useful information out of it? What do you think?
Yeah, that's a great question. And like so much in the public policy world, the devil is in the details here, right? I think on net, more information is better information, particularly given how limited the information is that we have now. So since we started writing the book, the FBI has expanded its use of force incident reporting. Compliance is still pretty low. More than half of police agencies just aren't participating in that voluntary data reporting program. I think there's the opportunity, I think there may even be a need for the federal government to, for example, condition burn grants or block grants to the states on the state level adoption of data collection laws. They can't require it, but we can certainly condition it. We can certainly incentivize it. There are some states that have data collection, although what exactly they require to be collected and how well agencies are complying kind of depend. Texas and California both have data collection laws regarding serious uses of force, which in Texas, I believe, is limited to police shootings. California is a little bit broader, but compliance is an issue there. There just aren't a lot of teeth to those laws. Nothing happens if the agency ignores the law. I do think that it can be really important. And not just because I'm an academic and a data head, but we do have a couple of practical examples about the effect that good data can have on public policy conversations. Maybe the most obvious one in policing is racial profiling data. Like in the late 90s and early 2000s, lots and lots of discussions and academic studies. But I don't think it was until states like Tennessee, which you may not have expected, started mandating data collection that we got sort of a universal statewide look and said, wow, this is really disparate, right? There are a lot of racial disparities in traffic stops or in consent searches during the course of a traffic stop. In the use of force context, I think we see something similar, and I'm going to sort of take my digital hat off to New Jersey. Is anyone from New Jersey? New Jersey is super weird in some ways. Yay, Justin, I see your hand went up there. So the New Jersey Attorney General has incredible administrative power over police agencies. One of the phrases that I've heard from friends in New Jersey, in the New Jersey policing world, is every agency has two chiefs, the chief and the Attorney General. Well, what this has allowed New Jersey to do is standardize its use of force reporting, which it did a decade or more ago. And that allowed the New Jersey Advanced Media, a media company, right, to do public records requests for all of the use of force reports in New Jersey from every agency over a multi-year period. And that allowed us to draw apples to apples comparisons. We had standardized definitions, we had statewide data, and they could say things like, smaller cities use a disproportionately high amount of force. Well, what does that tell us? It tells us that there might be a training or supervision or equipment issue. It gives us a sense of where and how we should direct resources. We could do the same thing in every state. It would be a slog, to be very clear. It would be politically unpalatable. It's not that it would be so resource intensive, difficult that we can't do it. It's that the main obstacles here, I think, are lack of political will. So I do think it's important. I think we should do it. And if we look at some of the changes to use of force that the New Jersey Attorney General just recently made, I think this month or last month, changing use of force policies, which again, the AG can do because of the idiosyncrasies of New Jersey law, those changes would not have happened without the statewide data that New Jersey Advanced Media was able to collect. So I'm a big believer in evidence-driven public policy, and that means we need to have the evidence. I think that's a hand. I think it's because of the pinning here.
I don't see any hands, but please raise them if you'd like.
I have mine up.
He was
having
okay, great.
Some technical problems, so I had to do it the old-fashioned way.
Great.
Seth, this was a great presentation. Thank you. Hearing you talk about the book made me want to buy it and read it. So mission accomplished from that perspective. Just two questions for you. One is, I guess, a substantive question about the book and what's in it, and then a second question is more selfish about implications for me when I teach criminal law next in the fall. So the first question is, I guess it's about chapter 2, right, where you move from constitutional law to state law. I might have missed it in your presentation, but it sounded to me like your state law discussion is mainly focusing on state substantive criminal law. And I was interested in what kinds of civil option, right, civil damages type options. I mean, obviously we have federal statutes keyed to the underlying constitutional standards, right, like Section 1983 most notably. But it seems like you want to make the very important point that we should also be talking about laws that are disaggregated from the constitutional standards. So in other words, laws other than Section 1983. And so I guess my question is, what else might fall under a state law rubric, but more on the civil side of lawsuit options, outside of the Section 1983 rubric? And then my second question is, how do you teach excessive force in a substantive criminal law class? Like, so many of the case books that I've seen just do what you criticize, right? They put Tennessee v. Garner in there, Graham versus Connor. That's the way I taught it last year. And I realized midway through the semester, this makes no sense. In every other part of this class, we're having our students read criminal statutes, work through statutory interpretation, apply them to facts, and then all of a sudden we're talking about Fourth Amendment standards that are designed for wholly separate purposes. So if you were teaching that unit, which I assume you do because you teach crim, what are your suggestions?
Yeah, great questions. So we don't just talk about the criminal standards. We try and make it a state law discussion. And in every one of those first 4 chapters, the first thing we talk about is, where does the standard apply? Where are we even going to see it? So in the con law example, right, you see it in 1983 cases, you see it in pattern and practice investigations under 14141, you see it in prosecutions under 242. We do the same thing with state law. And yes, state law crimes are obviously maybe the clearest example of where you see the state standards, but there are also state civil suits, states under their equivalent of the Federal Tort Claims Act, the various states tort claims acts, that's a weird set of plurals there, states tort claims acts. There's also regulatory law in the states, right? So almost all of the states, 44 presently, certify officers and can decertify them. And in many, although certainly not all, an officer may be decertified for failing to meet the state standards on use of force, the state law for use of force, even if they didn't commit a crime. Some states like New Jersey, there needs to be a criminal conviction, but we see the state law standard play into, at least in many states, an officer certification decisions or a state's decision whether to revoke an officer certification in the states where they can do that. What we don't do in the chapter is really distinguish between state laws, state statutes that authorize the use of force and state statutes that provide a justification defense for a use of force. For our purposes, we're sort of viewing those the same way. It doesn't matter whether the state says you can do this or whether the state says you can't be punished for doing this. That's an important distinction legally. And we can go back to that deadly force and fleeing felon rule to explain why. A state does not have the authority after Tennessee v. Garner to authorize a state, to authorize officers to use deadly force to prevent the escape of a fleeing felon. Like, that would be unconstitutional. States can't do that. However, states don't have to punish an officer who does do that. There's nothing in the Constitution that requires states to make that a crime or to not provide a defense to criminal action there. So we try and lay that out a bit in the chapter. We also talk about in the chapter our focus is on police-specific laws, a police officer's use of force. But one of the interesting questions that can come up in substantive criminal law is the connection between those police-specific authorizations, like the use of force statute, and a self-defense statute. For example, we talk about a couple of cases in Florida where officers were being prosecuted for violating the state use of force statutes. And the officer said, okay, well, even if I violated the state police use of force statutes, my actions were permissible as a matter of the state's self-defense law, the general, not police-specific self-defense law. And there's, I think, a whole discussion to be had about whether the specific should control the general, right? Whether officers should be able to invoke both police-specific state statutes and more generalized self-defense statutes. In that case, circuits in Florida actually disagreed. The Florida Supreme Court said, no, officers can invoke both police-specific authorizations to use force and more generally the self-defense laws. I'm not even sure if I got to the answer to your first question, so let me take the second question on with that acknowledgement. I don't teach use of force in substantive criminal law. I teach it rather, in some years, depending on how the semester is shaping up, I will cover it briefly in criminal procedure where it makes the most sense to talk about the Fourth Amendment standards. But most of my thrust on it is I teach a police law and policy class, and we spend 2 or 3 weeks talking about use of force. And we hit each one of the different standards to compare and contrast and explain how they apply differently. My criminal law class, my 1L criminal law class, is pretty tightly a statutory interpretation class. We'll certainly get into policies. I usually have 1, maybe 2 days a semester where we'll talk about hot button issues without necessarily doing much in the way of reading. So it may come up there, but I don't get into depth with it. Maybe I should, but I tend not to in criminal law.
Okay. We have a question from Mike Liberite.
Hi, I'm not a law student, but sort of interested in communities. So these are sort of interesting to me. Is there any evidence that a sub-community, say an underprivileged community, can differ from the police in the general total city? And how costly would it be if police were asked to follow a different policy within a sub-community as far as recruiting police, etc.? Does it make sense, or should I expand?
Can you expand a little bit on the first part? I definitely got the second part, but I'm not entirely sure what you're asking on the first part.
An underprivileged, call it black, because generally they correlate, would like possibly to have police less forceful against members of them in them. But the police say, if you do that, we're just not going to come in and police your community, or you can't hire police for that style.
Yeah. Okay. Yeah, that makes perfect sense. So I suppose it, on one level, I can see it being somewhat difficult for an officer who is working at one agency to apply significantly different standards depending on, which side of the street they're standing on. Am I in this community or am I in that community? Which formal rule applies? I don't think it's necessarily impossible, depending on what we're talking about. So I live in Columbia. I live just outside the city limits of Columbia here in South Carolina. And the city of Columbia is weird because the city actually exists in two different counties. And it means that when the city police officers arrest someone in one spot, they take them to one county's booking facility. And if they arrest someone in another spot, they take them to another county's booking facility, and the paperwork's different, right? That's an easy example, but it's entirely possible for officers to say, okay, in different situations, slightly different rules apply. It's also, I think, important to recognize that officers absolutely use, at least informally, different standards when they are dealing with different individuals, right? Officers don't interact with everyone in exactly the same way, nor frankly would we want them to. That would be sort of equality rather than equity, if that makes any sense. So I think it's entirely plausible, depending on how detailed we're getting, I think it's entirely possible for a community to, in a sort of ideal democratic way, to communicate with its police agency and say, look, we really want you to ramp back on, for example, traffic enforcement in this neighborhood, or ramp back on marijuana enforcement in this neighborhood, or approach people differently here. That's plausible. And certainly police agencies are used to allocating their resources differently. They're used to saying, all right, guys, we've had a lot of speeding complaints on this stretch of road, so make sure you hit speeding pretty hard. Or we're getting a lot of complaints about rudeness during traffic stops over here, so make sure you're introducing yourself and acting professionally and the like. That part would be easy. Another possible solution here, and this is where we see a lot of fractured police agencies, or a lot of fractured local governments, is incorporate and form your own police department. I'm actually not a huge fan of this. I think we have too much fragmentation in local policing, but it's at least worth sort of mentioning. That Ferguson, Missouri, like this little town that almost no one had heard of prior to the Michael Brown shooting, it's one of, do you remember, Brandon? It's like 56 or 64 separate municipalities in the St. Louis area.
Yeah, just in that one area. Yeah.
So like, it's nuts that they have a whole ton of these. Now, I'm not saying that that's a good idea writ large, but it is one way that local communities, if they wanted to say, look, I don't like the way I'm being policed here, I want to be policed differently. Sometimes communities say, all right, well, we're now a city and we're going to have our own police department. Unfortunately, that tends to be the cities that have the means to do that, right? Not always, but often it's cities splintering out. It's the city of Sandy Springs, right, in Atlanta. That's where my in-laws live. Beautiful area, a lot of resources in Sandy Springs. They could afford to incorporate pretty easily. I think maybe the bigger picture answer to your question, Mike, might be a more explicit recognition of the fact that officers do behave differently in the neighborhood that I live in now, say, and the kind of rough neighborhood that I grew up in. If we had more explicit recognition of that, then we could say, look, that thing you're already doing over there, we're not asking you to apply different standards. We're actually asking you to apply the same standards. That thing that you're already doing over there, where you approach people with procedural justice principles in mind, and you're using good tactics and you're minimizing the use of force, do that, but everywhere, which I think is going to get less pushback from police, who are going to raise the, look, you can't expect us to apply two different standards. It's very confusing. In fact, one of the big arguments, and I think this is a complete straw man, but one of the big arguments that police organizations have made about any any proposal that they go beyond the sort of objective reasonableness Graham-Connor standard is, well, that would be super confusing, right? We can't have different standards that apply. Okay, well then make it one standard, but make it a good standard. I think that's my big takeaway there.
Thank you.
So related to that, are you a fan of not necessarily police abolition writ large, but abolishing lots of small departments?
Yeah, so I am not an abolitionist in the large sense. I am definitely I don't know what the right terminology is. I'm a shrink the footprint person. I think we as a society have put police in the position of dealing with social issues that they can't deal with, right? That they're not equipped to deal with or trained to deal with. It's ridiculous that we rely so heavily on police to deal with school discipline and homelessness and poverty and substance abuse and alcoholism and anger issues and a whole other web of social ills that we have fundamentally failed to create an acceptable social service infrastructure for. So with that said, I think there's a lot of room to build up that infrastructure in a way that could decrease the reliance on police resources. But I think we'll always need police resources. I think, looking at the history of human civilization, we've always had a police function, even though police agencies are relatively new, right? Like the Code of Hammurabi and the fines that it imposed and the punishments, it implies a police function, even without a public police agency. And I'm very skeptical of the idea of really going hard on the abolished police agencies, because I think what will result is a bunch of private police agencies, and that doesn't sound equitable to me. The neighborhoods that can afford private security companies will buy private security, and those that can't won't. I'm not a sort of big picture police abolitionist. I do think the fact that we have 18,000 police agencies is nuts. We're not the only country to have localized policing. There are a few others. Most other countries have national police or provincial police. They might have state police, for example. But the fact, again, that we have 50 some odd or 60 some odd different cities, each with their own police agency in the St. Louis area, doesn't make a lot of sense to me. And I think it lends itself to some of the most destructive aspects of modern policing. Revenue generation policing, or policing for profit, what economists call rent-seeking behavior, when the government is taking resources but without providing a corresponding benefit. That's horrible. It's awful, right? It undermines policing to a tremendous degree. And I think hyper-localized policing kind of sets the stage for it. So I suppose I'm more comfortable with the idea of examining consolidation and getting rid of particularly some of the smaller police agencies. There was a news story a while ago about one in the Miami area. I forget which city it was, but the officers were criticizing the police chief in the city for not appropriately training and equipping the SWAT team. And it was a 17 officer agency. One, why does a 17 officer agency need a SWAT team? Two, why do we need a 17 officer agency? Are you really saying that we can't provide police services by, getting it from Miami-Dade or something? Like, is that the best way to do this? I have my doubts. I ramble. I apologize, folks. I'm very long-winded.
We have a question from Caitlin.
Hello. Thank you for your presentation. I'm a PhD student at George Mason University in economics, and this actually, what you've just been talking about sort of dovetails nicely with my research a little bit. And Eleanor Ostrom, I don't know if you're familiar with her and her work studying policing organizations.
I'm so bad with names. I really am. I have a horrible head for names and faces. It sounds familiar. I couldn't talk about it though.
Okay, no worries. Eleanor Ostrom, she's actually a political scientist, but she won the Nobel Prize in Econ.
That makes me feel worse. Thanks, Caitlin.
Oh, no, no worries. I think she's awesome. So I always tell people they should check her out. But she did some work in the late 90s, early 2000s, looking at this question of consolidation of police forces. And what she actually found in her work was that with consolidation, the community she was talking to actually became less satisfied with the police services they were receiving. And she talked about how it was, what she suggested was it was due to this disconnection between the services, the community wanted and the services that were being provided. So there was no longer that ability for police officers to know the community and therefore provide the services they were requiring. So I was just curious if, because you were saying you would prefer more consolidation, and if you had grappled with her work at all and how you would respond.
Yeah. Okay. So yes, great question. I'm familiar with the thread of her work. I'm sure I've read her work. I don't remember it offhand. Yeah. So first, I think defining the scope of the problem. This is already something that a police agency of size has to deal with, right? If you have a population of 100,000, which puts you in kind of the top 5% largest police the largest cities in the country, maybe even the top 3%, but is definitely not large in the terms of like New York or LA large. You have so many different communities that their expectations and desires for police, the way that they want police to behave, differ. So I hate using NYPD as an example, so I won't here. And the reason I hate it is because it is unlike any other police department in the country. Like, it is more than twice the size of the second largest police agency. But if we focus on the agencies that have a few thousand officers, they have exactly this issue of how we connect with whatever the community is, particularly with this idea of community, for lack of a better term, sort of community intersectionality, right? Communities aren't necessarily defined by geography. That's one way of defining a community. But do we mean the Black community? Do we mean this neighborhood community? Do we mean the community of people who live in these areas who are over 65? Okay, all of which is to say, community and community engagement and responsiveness is difficult because there are so many different ways to understand community. This is why, for what it's worth, I'm very skeptical of the concept of community policing. I don't know what exactly it means. I'm very comfortable and I'm very supportive of the philosophy of community policing. I have yet to see a police agency define it operationally in a way that satisfies me. So let's focus on the engagement and satisfaction. I think we have to recognize two things. One is that the metrics we use for community satisfaction are weird with policing. We tend to formally evaluate police agencies based on crime rates, but we know from many, many, many years of research that policing and crime, well, policing has a relationship with crime, but it's complicated, it's multifaceted. An agency can be doing everything right and crime can go up. An agency can be just a mess and crime can be going down. So one, I think that's, you know, how we evaluate police agencies is kind of a mess here. Two, I think we have to recognize like marketing and PR in policing. And that's a little different, like perceptions or data, but it's a little different than like hard metrics. I think it's entirely possible, for example, for a community to say, look, I'm not as happy with this police agency. I don't feel like I have the local input. But if we back off a half step and we look at the actual input, we would say folks are not going to any more nor any less of the police town hall meetings than they were. They are reacting, and it's a perception, it's a real perception, it's one that we should take seriously, but it is nothing to do with the actual delivery of police services, right? So I think the issue that we're getting at is complicated. I also think it's complicated by history. If we back up enough into, you know, and I'm talking about backing up 150 years or so, police were first and foremost constituent services, right? This was the era of political cronyism. Officers would buy their position, and their number one job was to make their communities happy, which sounds really good because it definitely puts public service and a service orientation at the very forefront of policing, which I generally applaud. But that also meant that for officers working in the German part of town, if an Italian walked through, you'd beat the hell out of him and toss him out of the, toss him down out of the end of the street. There is some concern about officers adopting and enforcing community norms when we may not want to grace those community norms with the awesome power of the state. And maybe the best example of this might be Clearwater in Florida that Scientology has taken hold of, or some of the fundamentalist communities where they have set up their own cities, their own police forces, and that may create some problems. So I think all of which is to say I don't have a good satisfactory answer to your question. I think we may have to acknowledge that satisfaction, which is very important and that we absolutely should take seriously, may be affected by consolidation. But we also have to look at the quality of police services delivered in a couple of different ways. Satisfaction is one important one, but maybe there are others that we need to consider too. I don't know if that's convincing or not, though.
Yeah, no, I mean, it's like you said, a complicated question and conversation to tackle. Just in terms of, I think Ostrom defined community more as that like geographical neighborhood. So less the like, idea of the Black community, but more like between this street and this street. Yeah, so that was great. It makes me wonder if you used the movie Do the Right Thing at all in your classes to start talking about these complicated ways of meeting community needs, and because they know the officers by name in that movie, right? So
yeah, exactly. I haven't, but it's a great thought. I mean, to set up this idea of community and really, so in my police law and policy class, we spend a day or two talking about community policing as a philosophy, and then we start doing criticisms of it, right? Amna Akbar wrote a great piece on community policing in the national security context, identifying some of the problems that can also play out in sort of the normal policing context. And one of the examples I use is in the same geographic area, let's say the downtown business community or the downtown business district, you have the business community and you have the homeless community. How do you balance the priorities for community policing between those two? And it's really complicated. I say this in my class all the time, but it's complicated in the sense that there are a lot of inputs, and it's complex in the sense that some of it isn't easily quantifiable. And there are a lot of simple sounding solutions, but one of my favorite quotes, if anyone can attribute this quote, I would love to hear it because I can't figure out who to attribute it to. But it's my favorite quotation recently. For every complex solution, there's a for every complex problem, there is a solution that is simple, elegant, and wrong. That's where I'm at.
So following that up, I think we have, since we have like maybe 10 seconds left, maybe you can just answer what role police have to play in the surge of homicides in major American cities, and what's the way forward post-Floyd for American policing. But maybe that should really be your next book. So.
Oh yeah, 10 seconds, big issues. I actually had this on my calendar until 2, which.
Oh, good. So, well, in that case, then we have some more time.
Okay, so police and homicides. This is one of those complicated factors where, like, folks who really have a far more empirically methodological bent than I do are fighting about this right now. I'm sure you've been following the Crim Prof listserv, where there's like a raging debate about what the effect is. Particularly a surge in homicides where we have the additional variables of COVID as a pandemic and the quarantines and the various restrictions on public life, and also the variables of a very contentious election and political environment. I do think that policing, I mean, we know that policing has an effect on crime. We know that certain police tactics, what's referred to as hotspot policing, tightly focused on geography or on individuals, can have an effect, a depressive effect, right? A downward effect on crime without necessarily just creating a redistribution of crime, right? I'm trying, oh God, what's the phrase? They're just relocating crime from one part of the city to another, right? I tend to be a little skeptical of the simplistic associations, like, for example, well, when NYPD started its stop and frisk, that really had a dramatic impact on gun crimes in New York in the mid 90s, right? I'm skeptical of that one particularly because the gun crime and violent crime decline started before stop and frisk, because other cities saw very similar decreases without using stop and frisk. Like, there are all kinds of factors that make me think that that probably wasn't causal. I do think it's possible that policing and some of the public discussions or the impacts on policing have affected crime rates and violent crime rates. But it's difficult because a lot of violent crime isn't between strangers, right? Like, most of it isn't gangbangers shooting each other in the streets. Certainly in certain neighborhoods, that's the case. But a lot of homicides are domestic. A lot of homicides are acquaintance homicides. Often there's, alcohol more than anything else involved. Those are the kind of crimes that are also very, very difficult for the police to do anything about. So I think it's a tough question. Yeah, there's Paul arguing that it is definitely policing. I think I agree with him to a point. I'm not sure I agree with him to the same extent that he takes it. I don't know, Brandon. You have more methodology than I do. What's your take on that?
I think that the crime patterns during this pandemic raise lots of very unusual questions. And we see some of the same things happening in cities that are very different in terms of the community relationship with the police, the number of police officers, and some of these analyses where they're cherry picking particular cities raise all kinds of concerns, because something common is happening actually in a lot of small, medium, and large cities, right, where domestic violence, shootings, and homicides are up, but most other types of crime are down. And it's a very, very unusual year, and we want to take some time to look at it carefully. I worry about anyone who's jumping to any conclusions about what we're seeing during this pandemic.
Yeah.
But that's the story of policing, though, is that people want immediate answers and expect the police to be able to solve social problems right away.
Yeah, quickly and effectively and fairly and happily and professionally, and like we have some crazy tensions in our expectations of police and the disconnect between our expectations and their ability to actually live up to them. Yeah, I agree. And one other point of caution, I don't think you can find a trend in a year. Let's revisit this in 5 years or 10 years and see if there's actually a trend. Or if there's a blip. And I do not mean to diminish the significant increase in homicides, and it is a significant increase in homicides in many places. But we're kind of in a super weird situation with the pandemic. So I'm yes, I think policing may be part of that picture, but I don't think it's easy to assign. Even doing a couple of regressions, I don't think it's easy to assign. I'm also, just for fun, I'm going to throw a link to my new paper in the chat window. Shameless self-promotion alert again.
Please do.
This is how the Fourth Amendment frustrates the regulation of policing. This actually grew out of the book. And the observation is, first, the Fourth Amendment, thank you, Justin. The Fourth Amendment doesn't do a great job of actually regulating uses of force because it's not intended to, right? The Fourth Amendment is about seizures. And there are a lot of uses of force, including police shootings, that don't count as a seizure for sometimes weird ways. But the big thrust in connection with what I was talking with Justin earlier, the big thrust of the paper is that state law and agency policy are supposed to have different regulatory objectives than the Fourth Amendment. So it doesn't make sense to me to just adopt the Fourth Amendment standard into policy, as we've seen in police agencies, or into state law, when the Fourth Amendment is about balancing the interests of government and the governed, but state law may be about balancing violence, for example, and agency policy may be about balancing professionalism and the police mission, right? So
Spring is going to be really interesting because states are thinking about actually developing their own law. And all of a sudden, like, lawmakers are actually think that it's something that can be on the table, that, oh, we can regulate police. And so, you know, we've been doing some tracking on our end just to follow the legislation being introduced across the states. And there's a lot of it. It's a huge project, but it's
yeah, I can't keep up.
Interesting.
I'm really glad you guys are doing that. I know, is it Council on Criminal Justice is doing some of that, where they have a bunch of the bills that have been proposed. It's so much, and it's so exciting. And our book came out. This was not planned at all. This was literally the way the calendar worked. Our book was published the day after George Floyd was killed, and almost immediately that meant that the laws we were talking about may no longer have been timely, because there are so many proposals and some adoptions. Not a whole ton just yet,
yeah.
But lots and lots of proposals on everything from chokeholds to tear gas and pepper spray and tasers. And so I'm really excited to see where we end up in a few years.
Yeah, it's pretty incredible.
I'm cautiously optimistic.
Yeah, I feel like the usual, like, accept understanding was that, like, lawmakers don't regulate police. It's up to their own best practices. They're the experts. We'll pass laws every year to, like, recognize some sergeant's retirement or pension fund changes, or, you know, like, ministerial stuff like that, budgetary stuff, holidays, you know, equipment.
Yeah.
Nothing that actually affects their job, because that's their thing. And all of a sudden that seems to be changing.
Yeah, there are states revisiting the Law Enforcement Officers' Bill of Rights and substantive standards for use of force. Like, it's a potentially powerful time, but it's only going to be that way if we continue to exert political pressure so that there is political will to get the stuff done. My two co-authors and I have an op-ed, which we did not title, because I don't know about you, but I've never been able to title my own op-eds. So it was The Atlantic, which I love because they let us get away with a 4,000-word op-ed. There's a link in the chat window. They titled it "How to Actually Fix America's Police." And one of the sad facts of policing is these are not new problems. These problems have existed for generations, in some cases over 100 years. And we know the solutions, right? Like, going back to Wickersham and Christopher Commission and the Knotts Commission, we keep seeing the same recommendations over and over again. What we need now is politicians to actually do it. We need elected officials to pass laws and say, all right, enough of this.
Thank you so much again, Seth. This is an incredible treat.
Thank you, everybody. My pleasure. I'm going to throw my my email address in the chat window if anyone wants, if I can spell my last name correctly. If anyone wants to email me, I'm happy to engage. So, thank you, folks.
Take care. Thank you all.